Welcome to the Deep Dive. Today we're pulling back the curtain on a part of the legal world you don't often see dramatized, not the crime itself, but the conduct of the lawyers. Imagine the pressure of a courtroom, the clash of arguments, the weight of a client's fate, and imagine that the lawyer's own behavior, their words, their attitude, suddenly become the central focus of a high-stakes legal battle.
Yeah, one that could actually end their entire career.
Exactly.
That's right. We're looking at cautionary tales from the bar, stories where the passion and zeal expected of an advocate, that fire, it just boiled over and led to some pretty severe professional consequences.
Right.
These aren't instances of dishonesty or criminal acts in the typical sense we think of. It's more about breaches of the stringent standards of courtroom conduct, the respect that the legal profession really demands.
So our mission in this deep dive is to take a close look at two real disciplinary cases involving Australian barristers. We've got a stack of sources, detailed tribunal decisions, pivotal appeal judgments, articles that, well, they really lay bare the human and professional drama.
Yeah, the raw details are quite something.
We're going to use these to reconstruct what happened, understand why it mattered so profoundly, and I think, crucially, extract the absolutely critical lessons these events hold, especially for anyone navigating or maybe thinking about, embarking on a career at the bar.
It's definitely a what not to do guide in some ways.
Think of this as a legal, true crime deep dive, maybe, focusing on the surprising places where careers can be jeopardized.
And we have our central figures. We'll begin with the saga of Henry de Suvero. He was an experienced and famously fiery advocate. His journey through a tense criminal trial led him down a very difficult disciplinary path. Then we'll turn to Bradford Caffrey. His story unfolded in a much humbler setting, actually, just an arbitration, but it carried equally significant weight regarding the standards expected of those who, hold themselves out as officers of the court.
Right, so two different settings, similar core issues about conduct.
Precisely.
We're going to follow their procedural journey step by step, from those initial courtroom clashes, through the formal investigation committees, the disciplinary tribunals, the subsequent appeals, and finally, the ultimate consequences.
And along the way, we'll meet the key players involved in judging their conduct and lay out the lasting implications these cases have for the very soul, perhaps, of the practice of law.
Okay, let's lean in and unpack this. Where do we start?
Let's start with Henry de Suvero and a criminal trial that became much more than just about the accused.
Okay, part one. The fiery advocate Henry de Suvero saga unpacked. Tell us about the setting for this initial drama. Where did it all begin?
The sources paint a really vivid picture. This began in a lengthy, emotionally charged criminal trial. It was before Her Honor Judge Helen Carpin in the district court. The subject matter itself was inherently sensitive, involving vulnerable young victims.
Right.
And the accused, Mr. Ken Dyers, he was 74 years old at the time.
So high stakes, vulnerability, and elderly accused, that creates a complex backdrop immediately.
Absolutely. And adding to the tension, the sources describe this palpable atmosphere in the public gallery. You had supporters of the accused's group, known as Kenja, sitting alongside opponents of the group.
Wow, so the public gallery itself was divided and potentially volatile.
It created an undeniable edge in the courtroom from the very start, yeah.
In that difficult environment, Judge Carpin made a key decision, I understand.
She did. Tasked with controlling these difficult proceedings, she decided to close portions of the trial to the public, specifically during the testimony of the underage complainants. It was clearly intended as a protective measure.
Okay, understandable given the circumstances. And this decision became a flashpoint for Henry de Suvero.
Precisely. Henry de Suvero was the defense barrister representing Mr. Dyers. The sources describe him as 63 years old at the time of the later tribunal hearing, so he was a mature, experienced lawyer.
And his background was quite extensive.
Oh, fascinatingly so. He was a U.S. citizen and a permanent Australian resident, qualified in New York law way back in 1961, held a Harvard law doctorate, cum laude no less, practiced trial law extensively in U.S. state and federal courts until 1987.
So decades of U.S. trial experience before coming to Australia.
Exactly. And by the time of this trial in Australia, he'd been practicing in NSW for over a decade, mainly in common law and criminal law. He appeared in over 40 criminal jury trials before Mr. Dyers' case and around 20 more after.
Okay.
The sources emphatically state, and I quote, "In every sense, he is an experienced barrister." It's also noted his instructing solicitor was present throughout the trial, which is standard but relevant.
So, despite all this extensive experience, Judge Carpin's decision to close the court sections, He saw it as a problem, a major problem.
He did. The sources note his deep-seated belief in the principle of open justice. He viewed the closure with, well, suspicion. He feared it could unfairly prejudice the jury, maybe suggesting the evidence was too sensitive for them to hear, or worse, that it might allow unfair treatment of the defense to occur, hidden from public and press scrutiny.
Right, the idea that justice must be seen to be done.
Exactly. That suspicion, layered onto the already tense atmosphere, it really set the stage for the escalating conflict.
And this conflict began almost immediately, I read. The sources mentioned something quite unusual happening on just the second day.
This moment is really critical to understanding how things started. On the second day of the trial, Judge Carpin turned to de Suvero's instructing solicitor, not de Suvero himself, which is unusual, but his solicitor, and asked directly, "Are you a member of Kenja?"
Wow. Asking the solicitor in open court about their personal association with the accused group, that seems highly irregular and potentially inflammatory.
It is described as highly unusual, yeah. And for de Suvero, given his U.S. background and age, this question apparently carried profound historical weight.
How so?
The sources highlight that he heard chilling echoes of the McCarthy-era hearings in the U.S., that infamous, often career-ending question, "Are you now, or have you ever been?"
Ah, I see the connection.
He bristled instantly. He sensed, as he later explained it, that his defense team was being unfairly smeared or targeted by association with a group that faced, well, considerable public controversy, being labeled a cult by some.
And his reaction to this question was swift and pretty dramatic.
It was. In a courtroom described as hushed, de Suvero made a really striking comparison. He remarked aloud that the courtroom felt as oppressive as those House Un-American Activities Committee hearings of old.
Comparing Judge Carpin's courtroom to HUAC, one of the most notorious, politically charged, and widely criticized inquisitorial bodies in modern U.S. history. That comparison, how did it land?
As the source vividly puts it, it landed with a thud. It was, by all accounts, shocking within Australian legal circles. The sources describe a visible reaction, Judge Carpin's lips tightening, the prosecutor showing disbelief. It was a dramatic, perhaps intended to be impactful, opening salvo in a battle that would quickly escalate from there.
It sounds like this really set the tone, and the friction just grew daily after that.
It did. The sources paint a picture of a defense barrister fighting tooth and nail, which is what you expect, but doing so with a tone that was increasingly accusatory, bordering on scornful. A stark contrast to the measured and frankly deferential style traditionally expected in court, especially towards the judge.
Can you walk us through some of the specific incidents from the trial, the ones the sources highlight as examples of this escalating conflict?
Sure. The sources detail several flashpoints that became the basis for the later disciplinary charges. These were referred to as particulars in the legal proceedings, essentially, specific allegations of misconduct. So one instance this relates to, particular 3.1 in the appeal source, involved an objection during re-examination. The Crown prosecutor, Mr. Desmond Carmody, he's also referred to as John Carmody in some places, was leading a witness. De Suvero's objection wasn't just the standard legal phrase like objection leading.
No.
He apparently exploded. "Objection, Your Honor. This is a classic leading question, totally improper on the part of the Crown." Now, the judge sustained the objection, but the sources note she frowned specifically at the commentary, the attack on the prosecutor.
Right, the editorializing.
Exactly. Then there was another incident, particular 3.5. A defense witness was being interrupted by the Crown. De Suvero didn't raise the issue calmly with the judge. Instead, he turned and accused the prosecutor directly in front of the jury of harassing the witness and jumping on her with a loud voice.
Oh, directly to the prosecutor with the jury watching.
Yeah. The sources describe the jury's eyes widening, unused to such direct personal accusations between counsel. Judge Carpin had to step in, reminding de Suvero to direct his comments to the bench, not to impugn his opponent directly.
The judge trying to maintain control.
And as the trial went on, de Suvero, according to the sources, became increasingly convinced the judge was biased against his client. He seemed to feel that every ruling against the defense on evidence or procedure just confirmed his suspicion that she was pro-prosecution. His frustration visibly mounted.
And this led to more confrontations.
It did. This growing distrust led to one of the most notable incidents, which became particular 1.3. The judge suggested a private meeting, maybe in chambers or perhaps even just in the corridor, to discuss allowing journalists into the closed sessions. Perhaps trying to find a practical compromise, balancing transparency with protecting the young witnesses.
Okay, seems reasonable on the face of it.
But de Suvero apparently saw it differently. He perceived it as an attempt at a backdoor deal, a horse trade about his client's fundamental rights. He abruptly refused the private meeting.
Refused it how?
In open court. With his voice described as quivering, he declared loudly, "I will not engage in any horse trading about my client's rights in a corridor."
Wow. That's openly accusing the judge of suggesting something improper.
It was an extraordinary moment, yeah. A very bold accusation to make publicly against the presiding judge.
Were there warnings from the judge about his conduct?
Oh, yes. The sources detail a moment when Judge Carpin, clearly concerned by his behavior, warned de Suvero about his tone. De Suvero responded passionately, talking about his duty to defend fearlessly, implying his outbursts were necessary protests against rulings he felt hampered the defense case.
How did the judge respond to that?
She delivered a stark warning. "Counsel, there is a line between fearlessness and discourtesy, and you are dangerously close to it."
That's pretty direct.
And de Suvero's response, apparently breathing heavily, was telling, "Your Honor, if I cross it, it's only because this trial." He stopped himself, but the sources convey that the atmosphere had become completely poisonous by this point.
And there was another historical comparison he made.
Yes, the Star Chamber comment. This became particular 1.2. Addressing Judge Carpin directly, de Suvero suggested the trial was turning into a Star Chamber.
Referencing the notorious, secret, unjust English court.
Exactly. It wasn't phrased as a question or even a submission, but as a statement. His voice apparently dripping sarcasm, effectively accusing the judge, again, of presiding over a secret, unjust process and undermining the integrity of his defense. Gasps were reportedly audible in the public gallery. Even the jury, when present, could sense the profound animosity.
Just incredible tension. Were there other specific accusations against the judge or the Crown?
Yes, the sources list several other significant ones. These included statements claiming the judge was untruthful, that she wouldn't let him speak, that she was unfairly scrutinizing his behavior, and gave preferential treatment to the Crown. These points relate to particular 7 in the disciplinary proceedings.
Accusing the judge of being untruthful. That's a very serious claim.
Extremely serious, and perhaps even more damaging. He accused the Crown prosecutor, Mr. Carmody, of employing trial tactics of deception. He also claimed the entire prosecution was political and tainted from the very beginning. This became particular 10. These weren't minor slips of the tongue. They were substantial, repeated allegations made against the officers of the court.
So it sounds like a sustained pattern of highly critical, sometimes accusatory and often defiant remarks and behavior directed at both the judge and the prosecutor throughout this very long trial.
Exactly. The sources make it crystal clear this wasn't just a single moment of losing his temper or one ill-advised comment. It was a sustained pattern of conduct that fundamentally challenged the authority and integrity of the court and his opponent.
After 42 grueling days of trial, what happened next? What was the outcome of the criminal case itself?
Well, the jury returned not guilty verdicts on 3 counts, but they couldn't reach a unanimous decision on 8 other counts. So, a mixed result, perhaps.
But the focus shifted immediately.
Completely. The sources highlight that in the aftermath, the focus firmly shifted away from the verdict itself and onto Henry de Suvero's conduct during those many weeks in court.
And the formal complaints followed swiftly.
Within days, Judge Carpin, understandably perhaps, filed a formal complaint with the NSW Bar Association. She detailed de Suvero's conduct, the comparisons she found insolent, the insinuations of bias, his refusals to follow her guidance on court decorum.
And the prosecutor.
Mr. Carmody, the Crown prosecutor, also lodged a complaint. His focus specifically on the accusations de Suvero made against the Crown, describing his courtroom behavior as unprofessional and deeply unbefitting an officer of the court.
So the courtroom battle ended, but a new, potentially career-threatening disciplinary battle began for Henry de Suvero.
Precisely. The Bar Association was now tasked with investigating a senior, well-known member of the bar based on complaints from both the bench and the prosecution. A very serious situation.
Must have caused quite a stir in the legal community.
The sources describe a significant buzz. Would the bar actually take formal action against one of their own, especially someone so experienced? What message would it send? It really raised the question, does decades of experience, a high-profile background, and a reputation for fearless advocacy give you a pass for this kind of conduct?
A question that needed answering. And that investigation led to the next phase. Facing judgment before a disciplinary tribunal.
It did, Part 2, the tribunal facing judgment. The process began, as is standard, with the complaints from Judge Carpin and Mr. Carmody being referred to a committee of the Bar Association. This committee investigated. They requested further information from the complainants. They sent the allegations to Suvero, giving him an opportunity to respond, and then reviewed all the material.
Did all the initial complaints proceed to the tribunal, or did the committee filter some out?
No, not all of them. The sources note that the committee actually recommended dismissing some of the complaints, which the Bar Association did, so there was some filtering. But the matters the Bar Association considered serious enough to warrant formal proceedings were compiled.
Okay.
This led to the filing of an information with the Administrative Decisions Tribunal, the ADT. This was filed on 10 July 1998. You can think of the information as the formal charging document in this context. It contained numerous particular allegations of unsatisfactory professional conduct, initially structured as those 10 main particulars, some with sub-particulars, laying out the specific incidents of misconduct they alleged occurred during the Dyer's trial.
So Henry Suvero was formally facing these specific allegations about his behavior in court. Who were the key players at the tribunal hearing itself? Who was deciding his fate?
The tribunal panel was a weighty one, comprising 3 members. Judge Kevin Finane served as the judicial member and chair. He was joined by Judge John Blackman, another judicial member, and Miss Lillian Bubniak, who was a lay member, bringing a non-lawyer perspective. This panel held significant power. They could potentially suspend or even disbar Suvero.
And who presented the case against him, and who defended him?
Representing the Bar Association, effectively prosecuting the case, was Patrick Garling, SC. He's described as a highly regarded senior counsel, and he was assisted by P. Skinner. Their role was to present the evidence from the trial and argue that Suvero's conduct met the legal definition of unsatisfactory professional conduct.
Yeah.
Defending Mr. Suvero was Francis McAlery QC, another respected Queen's counsel, appearing with M. Thangaraj. Their significant task was to contextualize the conduct, perhaps argue it was justified in the heat of a very difficult battle, or at the very least argue that it did not cross the disciplinary line into unsatisfactory professional conduct.
At the heart of the tribunal's task, what was the fundamental legal and ethical question they had to grapple with concerning Suvero's actions?
The tribunal's decision really highlights this core issue. They explicitly stated their task was to determine the standard of professional conduct expected of a barrister and then decide whether Suvero's actions fell short of that standard. The case put a very sharp focus on that inherent tension in the advocate's role.
Which is?
Well, it's the absolute duty to advocate fearlessly for your client, protecting their rights at every turn, versus the equally fundamental duty to the administration of justice. And that duty includes maintaining respect for the court and fairness to your opponent. It's a balancing act.
And barristers have that significant privilege of immunity for what they say in court, right? That complicates things.
It does. As members of a learned profession, barristers are granted the privilege of appearing for citizens in court, and their statements within those proceedings are generally protected from defamation claims. But, as the tribunal noted, this immunity comes with a heavy responsibility.
A responsibility to whom?
Primarily, they owe a paramount duty, above all else, to the administration of justice. This requires maintaining high standards, honesty, integrity, learning. If that courtroom privilege is abused, if it turns into gratuitous disrespect or crucially unfounded attacks, it can cause serious harm. Harm to the individuals targeted, harm to the reputation of the entire profession, harm to the advocate's own standing, and critically, it can erode that vital trust between the bar and the bench.
So did the tribunal acknowledge that a lawyer can challenge a judge if necessary? It's not just about being quiet.
Yes, the sources emphasize this point. The tribunal's decision explicitly stated that a lawyer may and indeed must stand up against perceived judicial impropriety or bias if it truly exists.
But there's a big but.
A very big but. They stressed the crucial condition. This must be done, provided it has a foundation in fact, and is raised respectfully. So, the key questions the tribunal grappled with concerning Suvero were really twofold. Did his accusations of bias or impropriety have a genuine factual basis in the trial transcript? And secondly, even if he honestly believed they did, was his manner of raising them respectful?
And based on their findings regarding those specific particulars, those allegations, the tribunal concluded he did not meet that standard.
That's correct. The tribunal went through the evidence meticulously. They examined excerpts from the criminal trial transcript. They heard oral evidence during the disciplinary hearing itself where Suvero gave his explanations for his conduct, often in an affidavit, and then tested in cross-examination.
Did he show any remorse or understanding?
The sources note that by the time of the tribunal, Suvero now appreciates that the remarks, could and should have been expressed differently regarding some points like the historical comparisons. He also conceded a duty of fairness to witnesses regarding another particular. But these concessions, while noted, weren't enough to overcome the weight of the evidence on the major charges.
Let's look at the findings on those key allegations. First, those comparisons he made, the advocacy, star chamber, and horse trading. What did the tribunal find there?
These were all grouped under Particular 1. The tribunal found all three proved as unsatisfactory professional conduct. The UAC comparison was deemed most peculiar, giving the impression Judge Carpin's court was oppressive without justification, and it was bound to cause offense.
Right.
The Star Chamber comparison was found to be presented as a statement of fact, not a submission, based simply on the court closure, and was also found bound to cause offense. And the horse trading comment, directly accusing the judge of trying to improperly bargain about his client's rights in private, was likewise hound-proved.
Their overall conclusion on those?
Their conclusion was pretty damning. None of these matters separately or together entitled the barrister to make these remarks. They pointedly highlighted that his extensive experience should have equipped him to handle his concerns without resorting to such offensive language. This conduct, they found, was unsatisfactory professional conduct. And this is a key point. His behavior, his lack of decorum and respect, was found to fall below the standard of competence and diligence expected. It wasn't just about his legal skill, but his professional judgment and conduct in court.
Okay. What about the accusations he leveled against the Crown prosecutor?
That was addressed, in part, under Particular 5.2. This dealt with Suvero's comment during cross-examination about the prosecutor's intervention being solely protective of a witness. It is designed to protect the witness and for no other purpose. The tribunal found that in saying this, Suvero had lost his appropriate professional detachment, he'd become personally involved, and the remark itself was indefensible in the circumstances. This, too, was found to be unsatisfactory professional conduct and was proved.
And the specific comments directed at Judge Carpin herself, apart from the historical comparisons like HUAC and Star Chamber.
These were covered in Particular 7. They included those very serious claims that the judge wouldn't let him speak, that she was not telling the truth, that she was unfairly scrutinizing his behavior, and gave preferential treatment to the Crown.
And the finding on those?
The tribunal found these remarks were offensive and deliberately calculated to be offensive. But crucially, they also found these allegations against the judge were not based on fact. They reviewed the trial transcript and could find nothing to support his claims that she forbade him to speak or was untruthful. The remarks were therefore found to be simply insulting and were proved.
Though no factual basis for some of his most serious claims against the judge, what about the most serious charge overall?
That was identified as Particular 10. This concerned his claim that the political nature of the trial had led to trial tactics of deception being employed by the Crown prosecutor. The tribunal considered this the most serious allegation they were dealing with, and described it as the most serious instance of unsatisfactory professional conduct seen in the whole case.
And their finding?
They found there was no proper basis whatsoever for this extremely serious allegation of dishonesty or deception on the prosecutor's part. It didn't matter what Suvero's subjective belief or frustration might have been. His conduct in making such a claim without foundation was found to be at the least reckless. Furthermore, his subsequent attitude, as shown in his affidavit and evidence before the tribunal, indicated no appreciation that his conduct could not be regarded as acceptable. This most serious charge was found proved.
So, while the tribunal dismissed some minor complaints, they found him not guilty. On a few points, like part of Particular 9, they upheld the major allegations. They found that his conduct, particularly the unsubstantiated accusations against the judge and prosecutor and the deliberately offensive and disrespectful comparisons, constituted unsatisfactory professional conduct.
Exactly. The finding was clear. Henry Suvero's conduct fell short of the standard of competence and diligence that the public is entitled to expect of a reasonably competent barrister, which is the core test under the relevant section of the Legal Profession Act. The determination of liability was a significant milestone, confirming he had breached professional standards.
With those findings of unsatisfactory professional conduct established, the tribunal then had to move to the question of penalty. What were the arguments presented on that front?
Patrick Garling, SC, for the Bar Association, argued for a serious penalty. He emphasized the need to protect the public interest, maintain public confidence in the legal system and the profession, and, importantly, deter other barristers from engaging in similar conduct. Given the sustained nature and the seriousness of the findings, especially the attacks on the judge and prosecutor, he argued that removal from the profession, disbarment, was potentially warranted.
Wow, so the Bar Association was arguing for the ultimate sanction. How did de Suvero's counsel, Mr. McAlery, respond to that?
Francis McAlery QC presented submissions focused heavily on mitigation. He painted a picture of de Suvero's long and dedicated career, highlighting his history of taking on unpopular causes and representing vulnerable clients. He stressed his otherwise unblemished disciplinary record in Australia over more than a decade prior to this incident.
Any other mitigating factors raised?
Yes, McAlery argued that the public nature of the proceedings and the findings themselves already constituted a significant public shaming and punishment. He also raised the potential severe financial impact of a suspension or certainly disbarment on a man in his mid-60s. He essentially pleaded for justice tempered with mercy, urging a penalty less than removal from the role.
How did the tribunal balance these competing arguments, the need for deterrence versus the mitigating personal factors?
The tribunal acknowledged the mitigating factors. They considered the positive character references submitted, his good record before and after the specific trial, and his later, albeit perhaps limited, appreciation that some remarks could have been better phrased. They stated quite clearly that these factors likely saves him from the harshest outcome, which strongly indicates that disbarment was genuinely considered but ultimately rejected.
But they didn't just let it go.
Absolutely not. They forcefully reiterated the seriousness of the conduct. They stressed this wasn't a single error in judgment or one intemperate remark. It was a pattern of behavior throughout a long and complex trial, attacking the judge's integrity, accusing the prosecutor of deceit without basis, doing so in ways that could potentially mislead or inflame the jury. They emphasized this pattern cannot be brushed aside lightly.
And the penalty they ultimately imposed, what was the final decision?
Henry de Suvero was found guilty of unsatisfactory professional conduct, and the penalty issued was a suspension. The sources specify this was a suspension from practice for a period of 3 months.
Okay, so not disbarment, which would have ended his career, but a significant temporary ban from practicing law. A clear message was definitely sent.
Absolutely. The penalty underlined that while his conduct wasn't deemed worthy of permanently ending his career, it was a serious breach of fundamental standards demanding a punitive response. The news, as you can imagine, was digested within the legal community, a senior, experienced barrister suspended. It served as a stark reminder to everyone, particularly those starting out, that there are lines that simply cannot be crossed, and experience doesn't provide immunity from consequences.
But de Suvero's fight wasn't over yet, was it? He appealed the tribunal's decision.
He did. His saga moved to the appellate level. He sought to challenge the tribunal's findings of unsatisfactory professional conduct and potentially the penalty imposed.
Part 3. The appeal, scrutiny, and affirmation of standards. So the case went before a higher panel for review.
That's right. The setting shifts again, this time to the perhaps more formal and imposing appeal panel courtroom of the Administrative Decisions Tribunal. The panel for the appeal consisted of 3 members. Justice Kevin O'Connor, who is the president of the ADT and a district court judge he provided. Alongside him were Mr. David Officer QC, another judicial member with deep experience, and Mr. John Geddes, who was a non-judicial member. Their task was to review the entire record of the tribunal proceedings, the original trial transcript excerpts, the evidence presented to the tribunal's detailed reasons for its decision, and the legal arguments made on appeal.
And who represented the parties at this crucial appeal stage? Was it the same legal teams?
Yes, the legal teams remained consistent. For the applicant, Henry de Suvero, challenging the decision, it was, again, Francis McAlery QC leading M. Thangaraj. Representing the respondent, the NSW Bar Association, defending the tribunal's decision was Patrick Garling SE leading P. Skinner.
What were the main arguments de Suvero's legal team presented on appeal? What were they challenging?
The central argument, the most significant legal challenge to the tribunal's findings, was put forward as ground 1 in the appeal documents. De Suvero's counsel argued that the tribunal fundamentally erred by applying the legal definition of unsatisfactory professional conduct, or UPC, to his in-court advocacy.
Hang on. They argued that the standard of unsatisfactory professional conduct didn't apply to what a lawyer says and does inside the courtroom.
Exactly. That was the core of their legal argument on this point. Their contention was that a barrister's in-court conduct should only be regulated by either the higher standard of professional misconduct, which traditionally required conduct to be viewed as disgraceful or dishonorable in the eyes of one's professional peers, a much higher bar, or, alternatively, through the trial judge's immediate power to deal with contempt of court.
So they're trying to narrow the scope of unsatisfactory professional conduct.
Precisely. They argued that the statutory definition of UPC, which refers to conduct falling short of the standard of competence and diligence, was primarily intended to apply to a barrister's duties to their client, things like preparing the case properly, giving sound advice, managing the client's affairs diligently. They argued it wasn't designed to cover contentious interactions, the cut and thrust of argument, with the judge or opposing counsel in the heat of battle. They essentially said, this case wasn't about him lacking legal skill or diligence for his client. It was about his courtroom exchanges, and UPC isn't the right tool for that.
That's a really fundamental challenge to the basis of the tribunal's entire ruling. What were their other main arguments on appeal?
De Suvero's team also raised arguments covered in grounds 2, 3, and 4, suggesting the tribunal failed to properly evaluate the conduct of all the participants in the original trial. They implied that the judges and the prosecutors' actions should have been given more weight as potentially provoking or justifying De Suvero's responses.
Sort of a context matters argument.
Yes, essentially. They also argued that the tribunal applied what they called a strict liability test, meaning they assessed De Suvero's conduct in isolation without sufficiently considering his subjective state of mind, his motivations, or the context of the perceived impropriety by the bench or crown, which he claimed prompted his actions. They argued this was an error, because lawyers are allowed, even sometimes obligated, to respectfully point out judicial impropriety if it genuinely exists and has a factual basis.
So a multi-pronged attack on the tribunal's reasoning. How did the Bar Association's counsel, Mr. Garling, counter these arguments? How did they defend the tribunal's decision?
Patrick Garling, SC, strongly defended the tribunal's decision on all fronts, arguing it was correct on both the facts and the law. He firmly rejected the central idea that UPC doesn't apply to in-court conduct. He asserted that barristers carry their professional obligations with them at all times, and especially in the courtroom, which he described as the critical stage for the administration of justice.
So no special immunity inside the courtroom doors.
Exactly. He contended that a failure to maintain the necessary standards of respect and decorum in court is, in fact, a failure of competence from the public's perspective. Part of the competence and diligence expected of a professional barrister is knowing how to behave effectively and appropriately, even under extreme pressure.
That's an interesting way to frame it, that proper courtroom behavior is actually part of the barrister's fundamental competence and diligence.
Yes, framing it that way was key to their argument that UPC did apply. Garling, SC, also argued forcefully that De Suvero's conduct was not justified by any genuine impropriety by the judge or prosecutor, reinforcing the tribunal's factual finding on that crucial point. He stressed that the tribunal did consider De Suvero's explanations and the context, rejecting the claim that they applied a simplistic, strict liability test.
Did he point to the tribunal dismissing some charges?
Yes, he highlighted that the tribunal had shown careful discernment by dismissing some of the original charges where the line wasn't clearly crossed. He argued this actually supported the strength and validity of their findings on the major particulars that were upheld. He emphasized again that this case involved a sustained pattern of conduct attacking the judge's authority, making serious, unsubstantiated accusations against the prosecutor, and potentially trying to influence the jury through his theatrics, which he argued amounted to tactical misconduct designed to make the trial a spectacle rather than a search for truth.
It sounds like a real clash over the very definition and scope of professional responsibility right there in the courtroom. What was the appeal panel's definitive ruling on all this?
On 29 March 2001, the appeal panel delivered its judgment. The outcome was a clear and decisive affirmation of the tribunal's decision. The appeal was dismissed on all liability grounds. That covered all 16 grounds raised by De Suvero's team, which refined those initial 10 particulars. Henry De Suvero lost the battle on whether his conduct was professionally acceptable. The tribunal's finding stood.
So his main argument, that unsatisfactory professional conduct didn't apply to his in-court behavior, was definitively rejected.
Decisively rejected. The appeal panel's judgment provided crucial clarity for the entire profession on this point. They explicitly stated, in words that have been quoted many times since, that the disciplinary system does not stop at the courtroom door. A barrister's professional obligations are ever present, especially in the courtroom where the administration of justice actually takes place. They fully agreed with the tribunal that de Suvero's contentious remarks and serious accusations were not justified by any genuine impropriety by the judge or prosecutor.
And what did they say about that crucial balance between fearless advocacy and respect for the court?
The judgment firmly reiterated the established principle. A barrister has the right and indeed the duty to be a fearless advocate for their client, but not to be a disrespectful one without solid grounds. The appeal panel upheld the tribunal's specific findings on all the key incidents: the HUAC comparison, the Star Chamber comment, the horse trading accusation, and the serious unfounded attacks on the Crown. They all stood as proven instances of unsatisfactory professional conduct. The judgment's conclusion was completely unambiguous. In the eyes of the law, Henry de Suvero did cross the line, and the guilty verdict stands.
This ruling wasn't just about Henry de Suvero then, was it? It seems like it set a really important precedent for the bar.
Absolutely. It provided definitive clarity for all barristers, particularly maybe those starting out or facing difficult trials. It cemented the principle that you simply cannot excuse unprofessional, disrespectful, or unsubstantiated attacks by hiding behind the drama of the trial or by merely asserting perceived unfairness without a clear factual basis. The rules of courtesy, honesty, and respect apply, as the judgment implies, even and especially when the pressures of the courtroom peak. The decision stands as a vital precedent, a stark caution that passion and dedication, however genuine, must always be channeled within the strict bounds of professional decorum and respect for the institutions of justice.
So, the liability question was finally settled. His conduct was definitively found to be unsatisfactory professional conduct. What was left of the case at this point?
Although he had lost the appeal on liability, de Suvero technically could still challenge the penalty imposed by the tribunal, that 3-month suspension, and he could certainly challenge the order for costs that would likely follow the Bar Association's comprehensive success. This moved the saga into its final phase, dealing with the consequences.
Part 4. The consequences serving the penalty, paying the price. So by mid-2001, the formal disciplinary case was finally drawing to a close.
It was. The sources describe this final stage unfolding in a much smaller, less formal hearing room of the ADT appeal panel. The drama of the main hearings, the teams of senior and junior counsel, all that was gone. Henry de Suvero appeared alone, representing himself.
He chose to handle this final part himself, no lawyers.
Yes. After the appeal panel had so decisively dismissed his challenge to the findings that his conduct was unsatisfactory, de Suvero made what seems like a strategic decision. He formally withdrew his appeal against the suspension penalty. He accepted the 3-month ban from practice.
It sounds like he probably recognized the writing was on the wall regarding the penalty after losing so comprehensively on the liability appeal.
That's the strong implication from the sources, yeah. The same panel had just upheld the core, finding that his conduct was unacceptable. Further arguing against the specific penalty of a 3-month suspension would likely have been futile and perhaps costly. As the source speculates, maybe he hoped that accepting the suspension without further fight might earn him some consideration when the panel turned to the final, often painful issue: costs.
Ah, costs. Always the sting in the tail. The Bar Association had succeeded through the tribunal and then defended that success successfully on appeal. They would be seeking their costs.
Precisely. The appeal panel still needed to determine who would pay the costs of the entire disciplinary process that included the original tribunal hearing and both levels of appeal, liability, and now the withdrawn penalty appeal. Legal costs for such lengthy proceedings involving senior counsel on both sides for much of it are inevitably substantial.
And de Suvero, representing himself, argued against having to pay the Bar Association's costs. What was his argument?
He did argue against it, and the sources capture the nature of his plea quite vividly. He argued it would be unjust to mulct the barrister with the Bar Association's costs of prosecuting issues against the barrister, which the Bar Association should not have litigated.
What did he mean by that?
He was referring specifically to the original complaints or particulars that the tribunal had ultimately dismissed. Remember, the Bar didn't succeed on every single allegation initially brought. He was arguing that the Bar shouldn't recover costs for the parts of their case that failed. He contended the Bar Association should only be awarded costs for the specific issues where they succeeded, effectively asking for the costs order to be apportioned.
Did he raise his personal financial situation as part of this plea?
Yes, and this added a particularly poignant, almost dramatic element to this final stage. De Suvero highlighted his financial circumstances to the panel. He revealed that his professional indemnity insurance, the type of insurance that lawyers rely on to cover them for legal costs, Orders arising from disciplinary matters like this, his insurer had recently gone into liquidation.
Oh, no.
Yeah.
That's incredibly bad timing and just terrible luck.
It really is. The sources note this was actually a known event around that time, a specific insurer failure that left many professionals unexpectedly uninsured for certain liabilities. Suvero was effectively telling the panel that any costs order against him would have to be paid personally, out of pocket, entirely from his own funds, with no insurance safety net. He argued that a full costs order, given the situation, would be financially ruinous for him at this stage of his life.
A desperate plea. How did the Bar Association respond to his argument about apportioning costs and his plea about financial ruin?
The Bar Association maintained their position. They claimed costs for the issues on which they had succeeded overall. They did acknowledge that the relevant legislation didn't require them to pay Suvero's costs for the specific issues on which he had effectively won by having charges dismissed. But they sought their costs for the overall proceedings where they had clearly prevailed on the substantive and most serious matters. They essentially argued that the tribunal was in the best position originally to assess costs, and their overall success warranted a costs order.
And what was the appeal panel's final decision on costs? Did his plea have any effect?
The outcome was that Henry Suvero was ordered to pay the Bar Association's costs of the proceedings. This order encompassed the costs incurred both at the original tribunal hearing and the costs associated with the appeals.
So, despite his arguments about the dismissed charges and his really quite desperate plea about financial ruin due to the insurance collapse, he was ultimately made responsible for the bulk of the bar's significant legal expenses.
Yes. The exact dollar figure would be assessed later through a formal process, but the sources estimate it could easily be a five-figure sum, if not more, covering years of work, senior counsel fees, tribunal expenses, and so on. It was indeed described by the source as a heavy burden for a barrister nearing traditional retirement age, particularly having to find it all from his own pocket.
And that finally brought the formal disciplinary case of Henry Suvero to an end. A long and bruising process.
By late 2001, the lengthy and complex disciplinary saga was concluded. He served his 3-month suspension, during which he was legally unable to practice law.
And his return to practice after the suspension.
There was, as the sources put it somewhat starkly, no triumphant fanfare. He did return to the bar, but his name and the details of his case were now part of the public record, published in the law reports, discussed within the profession in ethics seminars and the like. His story became explicitly a widely known cautionary tale.
His legacy seems complex then, depending on who you ask. How is he remembered?
It seems quite divided. The sources note that differing views remain even today. For some, he is perhaps remembered as a kind of maverick hero, someone who had the courage, maybe misplaced courage, to stand up to what he genuinely perceived as an unfair or biased court, even if he did so imperfectly and crossed lines. For others, though, he stands as a clear, cautionary example of arrogance and incivility not to be emulated. Proof positive that courtroom zeal, however well-intentioned, cannot excuse fundamental breaches of professional conduct and respect.
So what's the overarching lesson?
The overarching lesson from his case, as the sources convey it, is perhaps that his courtroom passion, while possibly born of a deep belief in his client's cause and his view of justice, ultimately burned too hot. It led him to cross critical boundaries, resulting in significant personal and professional consequences.
A powerful story about the limits of advocacy, indeed. Now, you mentioned another case, Bradford Caffrey, unfolding somewhat in parallel, but with a different feel.
That's right, Part 5, the slow burn Bradford Caffrey's tale. If Suvero's case was a sudden, intense blaze of conflict erupting in a high-profile trial, Caffrey's was described by the source as more of a slow-burning fire that smoldered for nearly a decade before reaching its final resolution. It involves similar core issues of courtroom conduct and disrespect, but unfolded in a very different setting and over a much, much longer time frame.
And the setting was much less dramatic than a high-profile criminal trial like Suvero's.
Significantly so. The conduct that led to discipline in Caffrey's case occurred during an arbitration hearing. It was over a family financial dispute, and this happened way back around the year 2000. So a far humbler, less formal setting than a district court jury trial. These things often take place in a conference room, maybe with just the parties, their lawyers, and the arbitrator. But as the case starkly shows, professional standards apply nonetheless. The setting doesn't give you a free pass.
What kind of conflict arose in this less formal arbitration setting?
The sources describe instances of what they still term courtroom anger, even though it wasn't technically a courtroom, and really cutting sarcasm directed at the arbitrator and the opposing solicitor. It was behavior that, over the course of the arbitration, accumulated into a pattern that eventually, years later, led to a disciplinary reckoning.
Who are the main individuals involved in the arbitration itself and then the subsequent disciplinary case?
Okay, in the arbitration, we had a Mr. Dern serving as the arbitrator. Bradford Arthur Caffrey was the barrister whose conduct became the subject of the complaint. A really crucial figure for the disciplinary process turned out to be Mr. James Doyle. He was the solicitor acting for the complainant, who was the plaintiff in the arbitration. Critically, Mr. Doyle took careful, contemporaneous notes throughout the arbitration. These notes proved invaluable later because, unlike a court trial, there was no official transcript being made.
So Doyle's notes became the primary evidence.
Exactly. He later became the formal complainant to the Bar Association, using his notes as the basis. There was also mention of Minas Donalian, one of the defendants in the arbitration, who provided a statutory declaration supporting Caffrey for his defense at the later tribunal hearing. When the case eventually reached the tribunal, which wasn't until 2008, P. Skinner acted as barrister for the Bar Association, the same counsel involved in the Suvero appeal, and M. Barco represented Mr. Caffrey.
So the lack of a formal transcript meant Mr. Doyle's notes were absolutely key evidence for the tribunal years later.
Absolutely critical. The tribunal, in its 2008 decision, heavily relied on Mr. Doyle's contemporaneous notes and his oral evidence. They described his notes as careful, thoughtful, measured, and accurate. It really highlights a practical point for all lawyers. Even in less formal settings, without court reporters or official recordings, your conduct can still be meticulously recorded by others and scrutinized later. What you say matters, always.
What were some of the specific instances of Caffrey's conduct during that arbitration that led to the complaints and the eventual findings of misconduct? What did he actually say or do?
The tribunal's findings list several pretty striking examples, based primarily on Mr. Doyle's credible notes and evidence. For instance, Caffrey apparently called the plaintiff, the opposing party, obnoxious. This was noted as particular 8.4 in the findings. Even more seriously, he referred to the plaintiff as an abject pathological liar.
Wow.
When asked by the arbitrator, Mr. Dern, to withdraw the remark, Caffrey apparently withdrew the words abject and pathological, but stated that because he believed the plaintiff's answers were false and fraudulent, he would not withdraw the term liar.
So doubling down on calling the party a liar.
Essentially, yes. The tribunal found, and Caffrey later conceded during the disciplinary hearing, that this conduct was unsatisfactory professional conduct.
What else? Was his conduct towards the arbitrator also an issue?
Oh, very much so. He showed significant disrespect to the arbitrator's ruling when Mr. Dern disallowed certain cross-examination. Caffrey stated provocatively, "This doesn't matter. This is going up to the magistrate. I think you'll rule against us anyway. Why don't you rule against us and we will go home?"
Undermining the whole process.
Completely. The tribunal found this a clear failure to show courtesy to the arbitrator, and again, it was conceded as unsatisfactory professional conduct by the time of the hearing, particular 8.6.
Any more direct insults?
Yes. At one point, when asked by the arbitrator to look at him while speaking, Caffrey apparently replied, "I can't stand the sight of you."
Good grief. That's incredibly personal and disrespectful.
Highly personal, yes. Mr. Doyle's notes supported the substance of this insult, particular 8.9. Then, when asked later to conclude his cross-examination, Caffrey stated he was not near conclusion and threatened the arbitrator, saying, "I have a notice of appeal already drafted," particular 8.10. When the arbitrator called Caffrey's conduct abominable, Caffrey actually retorted, "So is yours."
Trading insults with the arbitrator.
It appears so, based on the notes. These exchanges, again supported by Doyle's notes, showed a direct confrontation with the arbitrator's authority and a profound lack of respect. He also dismissed the arbitration forum itself when a question wasn't allowed, stating, "We will see in the other court the rules of evidence will apply there," particular 8.11, just showing contempt for the process he was in.
Any other remarks?
There were some sarcastic and offensive ones. In response to objections, he apparently said to the arbitrator, "You scare me," and later, perhaps even more bizarrely, "I'll bring another pair of underpants along," particular 8.12. Mr. Doyle's notes supported the substance of these strange remarks. He also directly insulted his opponent's legal knowledge, saying to Mr. Doyle, the solicitor, "You do not know what relevance means," particular 8.13.
And the worst one, you mentioned one earlier.
Yes, perhaps one of the most egregious remarks came just before a lunch adjournment. Caffrey apparently referred to the possibility of the matter going elsewhere to be heard by someone with a brain. And then apparently turning to Mr. Doyle, he added pointedly, "Take that down to Doyle." Particular 8.14.
Directly insulting the arbitrator's intelligence and making sure the solicitor recorded it. That's astonishing.
It is deeply insulting and unprofessional. And this comment, like the others, was fully supported by Mr. Doyle's careful notes, which the tribunal accepted.
So these comments, meticulously documented by Mr. Doyle, led to him filing a complaint with the Bar Association. The formal information listing the charges was filed when?
The information was filed on 20 November 2003. However, and this is a key difference from the relatively swift path of de Suvero's case, which went from the 1996 trial to a 2001 conclusion, Caffrey's case involved, as the source puts it, a significant procedural history and delay.
How much delay?
Approximately 8 years passed from the conduct in the arbitration, which was around 2000, to the final tribunal decision, which wasn't handed down until 2008.
8 years. Why such a long delay?
The source indicates the delay was partly due to various procedural challenges mounted by Caffrey himself over the years. It actually required intervention from higher courts along the way just to ensure the disciplinary case could even proceed despite the passage of time. It highlights the complexities and potential for delay in the disciplinary system itself.
So a long, drawn-out process before he even faced the tribunal hearing on the substance of the complaints. What were the tribunal's ultimate findings and the outcome in Caffrey's case in 2008?
The tribunal in 2008, as we discussed, based its findings very heavily on Mr. Doyle's compelling notes and his oral evidence, finding him a careful and credible witness. They contrasted his account with Mr. Caffrey's testimony, noting Caffrey often downplayed or denied making the remarks. The tribunal generally preferred Mr. Doyle's contemporaneous version of events, noting that Mr. Caffrey's denials might simply stem from an absence of clear recollection after so many years, rather than deliberate falsehood.
And the standard of proof.
They found the matters alleged were proved on the balance of probabilities, but they applied the necessary higher standard of satisfaction given the seriousness of allegations of professional misconduct, sometimes referred to as the Briginshaw standard. This requires clear, cogent, and satisfactory evidence, even though it's technically a civil standard of proof.
And applying the relevant law, what was the finding on his conduct?
The Legal Profession Act 1987 applied to Caffrey's case, similar to de Suvero's, due to transitional provisions from later legislation. The tribunal found that his conduct, as evidenced by those specific remarks and interactions during the 2000 arbitration, clearly constituted unsatisfactory professional conduct.
So guilty of unsatisfactory professional conduct, what was the penalty imposed in Caffrey's case? Was it similar to de Suvero's suspension?
No, it was significantly less severe. Based on the source's description of the outcome, Mr. Caffrey received a public reprimand.
A public reprimand. Okay, so that's a formal censure, a public declaration that his conduct was unacceptable, a form of public shaming within the profession. But it's significantly less severe than de Suvero's 3-month suspension, and certainly worlds away from disbarment.
It is. The sources describe it exactly like that. A public shaming, undoubtedly embarrassing and damaging to his professional reputation, but far better than suspension in terms of immediate impact on his ability to practice. While the provided source excerpts don't detail the tribunal's explicit reasoning for choosing this specific penalty over something harsher, they do allow for some speculation on possible mitigating factors that might have contributed to this lesser penalty compared to de Suvero.
What factors might have led to that different outcome? Why a reprimand and not suspension?
Well, speculation based on the sources points to a few possibilities. First, the significant 8-year delay in the case actually coming to a final hearing. Having the disciplinary matter hanging over his head for such an extraordinarily long period might have been considered a mitigating factor in itself, a form of punishment already endured.
That makes sense. Anything else?
There was apparently no evidence presented of any similar misconduct by Mr. Caffrey in the intervening 8 years since the 2000 arbitration. This might have suggested to the tribunal that the conduct was perhaps an isolated lapse in judgment, or at least that he had since maintained proper standards and didn't pose an ongoing risk requiring a suspension. Additionally, the context is a potentially informal or frustrating arbitration setting, while absolutely not excusing the conduct, might have been viewed slightly differently in mitigation compared to the highly formal, public, and high-profile district court environment of de Suvero's trial. The stakes felt different, perhaps.
So despite the clear difference in penalty and setting, what are the critical lessons we can draw from Bradford Caffrey's case, particularly when we consider it alongside Henry de Suvero's saga? What's the takeaway here?
The Caffrey case powerfully reinforces one of the key lessons from Suvero, maybe even more starkly because of the informal setting. Professional standards of conduct and respect apply everywhere, absolutely regardless of the forum. Whether you are in the High Court, the Supreme Court, a local magistrate's court, or an informal arbitration taking place in a hired conference room, barristers must maintain courtesy, self-control, and respect for the process and all the participants.
It really highlights that there are lines you just cannot cross anywhere.
Absolutely. Lines like deeply insulting remarks about the intelligence of the decision maker, someone with a brain, or taunting an opponent's competence, you do not know what relevance means, are shown to be firmly off limits, full stop. They will likely lead to disciplinary findings if proven.
And his case also speaks volumes about the long arm of accountability, even if it sometimes moves very slowly.
Absolutely. The saga demonstrates that even if a barrister thinks they can get away with disrespect or unprofessionalism in a less formal setting, maybe feeling there's less scrutiny or no official recording, the system will catch up eventually. The wheels of justice and the disciplinary process may turn slowly, as they certainly did in Caffrey's 8-year journey from conduct to final decision, but they do turn.
Did the delay itself have broader implications?
Yes, the significant delay in his case also brought to light serious issues within the disciplinary process itself at that time. Memories fade, evidence can become harder to gather reliably after years, and crucially, public protection from potentially unsatisfactory conduct is held up while cases drag on. His saga, alongside others perhaps, likely contributed to subsequent reforms aimed at prosecuting complaints more swiftly and efficiently.
Caffrey's story feels, perhaps, as you said, more relatable to moments of everyday frustration that lawyers might feel in less high-pressure situations.
The source suggests exactly that it might be even more relatable for many practitioners. Because it touches on those moments, everyone in the legal world has probably felt the sting of a perceived wrong ruling, the frustration of dealing with an opponent or a process they feel is difficult, obstructive, or maybe even incompetent. Caffrey perhaps gave in to the very human temptation to vent those feelings publicly through sarcasm and direct insults.
And the lesson there is?
The clear message here is about the potentially high price of that momentary release, that catharsis, as the source puts it. The momentary catharsis of a snide remark can birth consequences far beyond the courtroom or arbitration room door. The prudent barrister, the professional barrister, the source concludes, learns from these examples. They choose instead to count to 10, take a breath, and choose their words wisely, even under provocation. That self-control is part of the job.
These two cases, Suvero and Caffrey, really do serve as powerful morality plays for the legal profession, don't they, when you put them side by side?
They absolutely do. And that brings us to part 6, the lasting shattered implications for the profession. The sources reflect on these stories precisely as morality plays about the soul of the legal profession. They aren't stories of traditional crimes like theft or assault, but of ethical and professional breaches. Yet they contain significant drama and incredibly high stakes, not just for the clients involved in the original cases, but directly for the careers, the reputations, and ultimately the livelihoods of the barristers themselves.
And they really expose the human dimension behind the sometimes formal, almost detached facade of the law.
Yes, very much so. They highlight how powerful human emotions, that intense desire to win, the deep, sometimes blinding belief in the righteousness of one's own cause, the frustration or even disdain for perceived incompetence or unfairness within the system, how these emotions, when left unchecked, can lead even highly intelligent, highly experienced, and otherwise capable professionals like Suvero and Caffrey into serious career-damaging error.
And they also underscore the vital, perhaps sometimes unglamorous, but absolutely essential work of the Bar Association and the disciplinary tribunals.
Precisely. They are, in effect, the profession's conscience and guardian. Their role in investigating complaints fairly and upholding professional standards, even when it means taking difficult action against their own members, is crucial work. It's necessary not just for the profession's own integrity, but to maintain public trust and confidence in the legal system as a whole.
And all of this brings us right back to that foundational principle you mentioned much earlier, the barrister's paramount duty.
It does indeed. These cases powerfully reinforce that fundamental principle for every single lawyer. Any lawyer's first duty is to the court and the administration of justice. The duty to the client, while absolutely critical and central to the role, comes in the context of that higher duty. It's a constant, sometimes incredibly difficult balancing act that every advocate must strive to master throughout their career.
So, consolidating the lessons from both these cautionary tales, Suvero and Caffrey, What are the key implications? What should aspiring barristers, or indeed anyone already practicing in the legal world, really take away from these stories?
I think the combined lessons form a pretty clear cautionary guide. First, remember that brilliance, legal skill, and courage and advocacy are vital, yes, but they are not excuses for incivility, for disrespect, or for making serious, unsubstantiated attacks. True courage for a barrister, perhaps counterintuitively, often lies in maintaining composure, exercising self-control, and upholding professional conduct even under immense pressure.
Okay, point one, talent isn't a shield for bad behavior. What's next?
Second, there are clear boundaries to acceptable advocacy. Crossing those lines by gratuitously insulting judges or opponents without any factual basis, by making serious, unsubstantiated accusations of dishonesty or bias, or by deliberately undermining the court's authority will lead to consequences. These cases prove it. Third, decorum matters profoundly. Professional decorum and courtesy aren't just about superficial good manners. They are fundamental to the proper functioning and the perceived legitimacy of the administration of justice. The rule of law isn't maintained just by the judge's gavel and authority, but also by the self-restraint, the integrity, and the honor demonstrated by the lawyers appearing before them.
Fourth point.
Fourth, professional standards apply in every single forum. The expectations of conduct are the same whether you are appearing in the highest court of the land before multiple judges or participating in an informal arbitration in a small conference room with just a few people present. Your professional obligations follow you everywhere.
And
Finally, accountability is real, even if it can sometimes be slow. Disciplinary action is a genuine possibility, as these cases show. It can happen even years after the conduct occurred, and even for instances of disrespect or poor judgment that might have seemed minor or perhaps justified in the heat of the moment. The system does respond. These stories, drawn directly from real disciplinary cases, they're not just abstract warnings. They are actively woven into legal ethics classes, into professional development seminars, into discussions within the profession. They serve as vital, practical lessons guiding future generations of lawyers toward the higher path, constantly reminding them that the practice of law is not just about winning cases, it's fundamentally about how you conduct yourself while striving to do so.
it truly is a challenging tension for any advocate, isn't it? You have that fierce, essential duty to your client, a duty to be absolutely fearless and zealous on their behalf. But then you also have that equally vital, arguably higher duty to the court and the administration of justice itself. These cases are just such powerful demonstrations of what happens when that delicate balance goes wrong, sometimes with devastating consequences for the lawyer involved.
Absolutely. They serve as enduring, sobering reminders of the high standards demanded by the profession and expected by the public.
So let's leave you, our listener, with this thought to ponder. Considering that fundamental tension inherent in a barrister's role, the absolute imperative for fearless advocacy for your client on one hand, and the overriding duty to the court and the administration of justice on the other, and keeping firmly in mind the stark disciplinary reality faced by Henry de Suvero and Bradford Caffrey when their conduct was found to have crossed the line. How does a barrister effectively challenge perceived unfairness, bias, or impropriety by a judge or an opponent, especially in the intense heat of battle, without themselves crossing that line into conduct that could jeopardize their own career? Who ultimately defines, or perhaps continually redefines through cases like these, that ever-shifting boundary between necessary courage and punishable contempt, between righteous passion and unprofessionalism, right there in the crucible of the courtroom?
It's a question that requires constant ethical reflection and careful judgment in the day-to-day practice of law. There are no easy answers.
Indeed. Thank you for joining us for this deep dive into these compelling and certainly cautionary tales from the bar. We hope these stories give you something important to reflect on, whatever your connection to the legal world.